Good evening and welcome to my show, Injured Workers of PA. The show is aired live tonight. It's August 19th, 2013. It's a live call-in show, so if you have any questions or concerns, you can please call in at 610-378-0426. I'd like to wish everybody that's watching this a happy Labor Day because it's coming up, and my show would have been aired on that day regularly, so hopefully you're tuning in tonight, and if you're not tuning in tonight, you're tuning in Labor Day. Happy Labor Day. Hope you've had a great summer, and like I say, this show is aired live, so please give us a call. Our topic tonight is workers' comp. There's a House Bill 1636 that's been proposed that we're going to discuss. If anybody has any questions or concerns concerning workers' comp on any avenue, whether it be that you have with your going through or experienced, please give us a call. Like I say, we're here to guide you with our support group and we'd come to your aid and try and guide you through the process of the workers' comp system. I'm your host. I'm Dennis Straub, and tonight joining us on the program is workers' comp attorneys, and I'm happy to say a couple new workers' comp attorneys that joined our group, our panel of attorneys. It's Glenn Nyman and Dina Brilliant, right?
Yeah.
Did I say that right? Okay,
Yeah.
Dina. Spelled with an I. I was thinking like Dinah, but it's Dina. But anyways, Dina, I'm glad that they're here with me tonight. They can answer any questions you might have or concerns that I'm not familiar with, and we'll go on with that throughout the show. If you need to reach them at some point in the future, their law firm is Brilliant and Nyman, and their number is 1-800-WORK-HELP. But you can also reach them through me. You can, which is injuredworkersofpa.org. You can call me at 610-376-7942. They have on the website, it's on the TV now if you need to contact me at all. I tend to take more time talking with individuals about their circumstances and what the attorneys can, and then I'd guide you to an attorney and whatnot. But please be aware that we're here to help you and guide you through the process. I'd also like to thank Berks Community Television and its sponsors for let us have this show tonight. And if there's an attorneys group out there or somebody that feels they have some extra buck in their pocket, they can sponsor my show. I'd appreciate it. You can contact BCTV and contact them and talk to me. And as far as being a sponsor, it's shown basically on every show. They show the underneath and at the beginning and in the middle and at the end of the sponsor for the particular show. So if there's anybody out there, please contact me or contact Berks Community Television. Now, those for you that are joining us tonight, this show is repeated on Wednesday at 5 p.m., Thursday at 8 a.m., Monday at 2 p.m., and again on its regular scheduled time, which is September the 2nd, and then again at Wednesday at 10 a.m., Friday at 3 p.m., and Sunday at 12 p.m. So there's a lot of airings, so you can really watch the program. Also, you can watch it archived, which is on Berks Community Television, bctv.org, at any time you want. And there's a lot of older shows, too, so please feel free to do that. What many of you know from past, Workers' Comp Act is basically, I feel, unjust totally. It was set up to be helping injured workers and in the process of wage loss and medical, and all they've done is nicked and picked at it and taken away your rights of the injured worker. Right now, the maximum workers' comp rate per week, statewide average weekly wage is $917. Basically, it's like 2/3 of what you made is what you're entitled to, and the cutoff is that for the rest of your life. Back when I got injured in 91, the cutoff was $436. At that time, I was making $770 plus benefits because I was a union construction electrician. But none of that comes into play. How much more you made above what what they allow, and it can really come back to bite you, believe me, and then hurt. They don't consider that even on the ongoing if you do settle your case and so forth. But at this time, I'd like to introduce my, like I say, again, my guests tonight, Glenn Nyman and Dina. Brilliant. I'm going to turn it over to you. You can tell about your firm and yourselves a little bit, and we'll discuss House Bill 1636 or anything that any of our call-in viewers might have concerning the show. Thank you.
Well, thank you, Danny. Our firm, Brilliant and Nyman, is we only practice in the area of workers' compensation. We've been around for almost 10 years now, and we have clients throughout southeastern and central Pennsylvania. We are both certified as specialists in workers' compensation.
Just to add a little bit more, even though we're new to the show and new to this organization, we've actually both been practicing workers' compensation for now 20 years for me, 21 years for Glenn. And the unique thing about our firm is this is all we do, is we only handle workers' compensation cases. Some people come to us and they've been to bigger firms where people dabble and do different things. The attorneys don't actually understand necessarily what's going on. Every workers' comp case is a big case to us because that's what we do. Where sometimes you go to a bigger firm, they have all different kinds of cases, and this is not their top priority. In addition to that, we did pass the test, the certification test, which did involve us needing to do prerequisites to actually even sit for the test. So that involved going back through our history, how many different types of litigation we've done, how many different workers' compensation cases, have we gone on to the appeals courts. Obviously, we've done all that in our practice for the last 20 years. Glenn and I, as he indicated, it's almost been 10 years since we became partners and opened up Brilliant Nyman, which has been probably the best thing we've ever done because now we're the bosses and we're able to handle our cases the way we want to handle them. And a lot of that has to do with sometimes when you're with other firms, you have other people deciding maybe how they thought you should handle your cases. We've always been able to put the worker first and be able to give our total attention to them. And as you indicated that you're able to give sometimes the injured workers more time when they call you up and you can talk to them, we're able to do that as well. Obviously with time being, because we are in court and out of court, but we do feel like, at least I feel like I'm able to give them a little bit more time. I don't have to punch a clock to my boss. If I'm there at 6 o'clock and I'm still talking to a worker, that's just the way it is. Sometimes it's stressful and they need to be calmed down and they need to know that everything's going well. So I guess that's a little bit about our firm. We have been around.
Yeah, and literally, can't stress enough how important it is that you get an attorney that you can have a rapport with, somebody that's willing to take the time, like Dina, and that it just, I mean, over the years, the amount of people I've talked to on their cases, and they've been distressed that attorneys, they can't get through to them, they won't address their issues. When you have a firm like this, it's going to be able to sit and talk with you and address that. And I found that one of the reasons I created this organization was that there was a need for people to take some of the stress off, to know what they're doing, to guide them through the process and give them information that they can give to their attorneys. And literally, because it's a very important part of their case and make your case stronger, the more they know, the more they can go back to say that to their attorney. The attorney can address that issue, get it on record. It makes the case stronger, and they win their case. Also takes the pressure off the individual that they're not being left out in the cold and not knowing what's going on. Where if an attorney's firm like this can take a little bit more time and talk to you to take that stress off, you're much better off. Is there anything you want to address before we start on the House Bill 1636?
No, we can always come back to some additional things.
All right, Glenn. So at this point in time, on our House Bill 1636, I found out that I got a call that this thing was being addressed by an individual, and I hadn't heard about it. And I thought, oh, not again, that they're trying to amend the act again and cause more harm to injured workers. And that's what it seems they do. They keep nitpicking at the act itself. And this one, it's more than nitpicking. Here they're wanting to amend the act and extend, instead of 90 days of medical treatment that they were wanting to push through. At one time it was, they didn't have any of that. And that went to 30 days, and then now it's 90. That you supposedly legally treat with their physician. And you can get around that. We can discuss that a little later on, but depending on if the employer followed the proper procedure to begin with. But now they're turning around on this act, wanting to make it basically that for the duration of your injury, I just can't believe this. Go ahead.
We've heard some rumblings for months now that the Chamber of Commerce and some of the legislature wanted to attack the medical parts of the Act and really take away rights of the injured worker as far as their ability to get medical treatment. And some of the things we had heard that they were looking at were changing the captive period or the panel period that you had talked about that had been extended to 90 days. We heard rumblings that they wanted to make it 180 days. We had heard that they wanted to do things with utilization review to better curb medical expenses. But as you indicated, what they're doing in this act is a tremendous departure from where they are right now. Under the old system, under what we have now, as you said, an employer, if they wish, can post a panel of doctors to choose from. And it can be a list of at least 6 providers, at least 3 of whom are doctors. And the employee can choose among that panel for the period of 90 days. After those 90 days, the injured worker then is free to choose whoever he wishes, or he or she wishes. In this situation, the legislature is trying to change the act to say that in addition to that panel posting, they can also have the panel posting of 1 or more coordinated care organizations, CCOs. And a CCO is something, a facility or a group that's approved by the Secretary of the Department of Labor and Industry, and it's basically a collection of physicians or a collection of healthcare providers. And if this 1636, if this House bill is passed, as you indicated, the injured worker would at no point have any choice of a provider. Throughout the life of his injury, for the entire duration of that work injury, that injured worker is going to have to deal with coordinated care organization that was personally selected by the employer or by the insurance carrier. And that is just a tremendous departure. Let me let you get a word in it.
Yeah,
go
ahead.
No, obviously, this is an unfortunate thing. Hopefully this will not pass. Right off, we should tell everybody to start calling all their representatives and tell them that you absolutely do not want this. Get your friends, get everybody else to say this as well. Glenn and I actually went through this. We went through the Act. We looked up the definitions. And what glaringly kept coming back to us is this is not what they're saying it is. This would be not just having an HMO. Basically, I get the impression from reading their intent, why shouldn't we have an HMO? People have HMOs all the time. Lots of people have HMOs. Why shouldn't your workers' comp be an HMO? This isn't that way. Glenn actually looked up, before we came, he looked up and saw, like if you went into one of Blue Cross or somebody, what is an HMO? What do you get to do? They don't pick which doctor or which facility you go to. They give you a list of doctors and a list of facilities. That's not what this would be. This would be specifically, you have to go to a specific organization. Who knows who you're even going to see? You go in, it could be a doctor. It could be a physician's assistant. It could be anybody, as long as it's somebody that's deemed to be qualified. At what point you're going to see a doctor, we don't know. The Act itself talks about it has to be reasonable timing. It talks about you have to have approved type medical providers. There's a lot of questions to be done, and this would not be like having your HMO. This would be, they're telling you, you go to Dr. X down the street, and then they can tell you where you go. And then it also goes as far to say that they can send you out to doctors for referrals. If you need a surgeon, they're going to send you to their surgeon. Obviously, there's many questions. The way it was written, the way the House bill was written, didn't change some other parts of the Act. It looks like there can be inconsistencies. But before we go into that, Glenn, do you think maybe we should start going over what the actual definition of a designated coordinated care organization is, since this is what they're telling everybody you're going to have to go to?
Well, what we have with the Coordinated Care Organization, which is contained within the Workers' Compensation Act itself, the idea of a CCO, I mean, the idea is reasonable. The idea is that it's one facility that has the resources or the ability to treat an injured worker throughout the life of the injury, that has the various specialists, that has the various tools to address anything that the injured worker needs. But I think one of the important things to consider, and tying into what you were saying, is that we're dealing with a place that was selected solely by the employer. There's another part of the Act that talks about an impairment rating evaluation. And when you get an impairment rating evaluation, a doctor that performs that isn't selected by the employer. It's not selected by the insurance carrier. It's selected by the Bureau. So it's randomly assigned. In this situation, that coordinated care organization has a tremendous financial incentive to act in the best interests of the employer over the patient. As long as that CCO stays on that panel list, that's a tremendous financial motivation, which creates a fairly significant conflict of interest.
It causes more harm to the injured worker, the victims being victimized all over again here. I mean, I can't stress that enough, how many times I've seen that in the past with the individuals got injured, not having the proper diagnosis to begin with, and that's why I thought this 90-day thing, I mean, you have to wait 90 days, now they're wanting on forever so they can hide the fact that instead of ruptured disc, the proper designation, they could say, oh, it's just a torn muscle or something. It irks me when I see this kind of stuff coming out and that they're constantly doing the nitpicking and taking away the rights of an injured worker. And like you say, the duration, it just irks the heck out of me. Go ahead, go on.
You had mentioned before about the panel as it exists today, and that there are some things that we can do.
Right.
I don't know if you want to call them loopholes, but some rights that the injured worker has that we certainly protect. There are requirements. The list has to be posted in a prominent place. There has to be an acknowledgement signed at the time of hire as well as after the time of injury, or as close as can be to the time of the injury. But even if all that's done, if there's a list out there that doesn't have a specific specialty or a certain specialty, then the injured worker can pick whichever specialist he or she wants. So if there's no orthopedic on that panel, or there's no chiropractor on that panel, or pain management specialist, whatever type of doctor the injured worker is looking for, they can select their own. But again, now if this House Bill 1636 is passed, that coordinated care organization has the ability to refer the claimant to any other specialty or any diagnostic test. So
you've got to go to them.
It certainly seems, it certainly seems like everything then is on the panel.
You have no control over your own, your own body or what you're going to do with it as far as in the future, that they can manipulate, do whatever they want. They might as well put a bullet in their head right off the bat, and that's the way I feel about it. I mean, how can they even consider something like this and right? And I did call a couple legislators already, and I asked for input, but I didn't get anything back from them at this point. In fact, I had invited Tom Caladrone, which is the office right above here in the building that VCTV is at, and basically, I guess there's legislation right now. He's doing things down in Harrisburg, so he couldn't be here, but it's just a matter of basically, if you look at who sponsored this bill, it's all big business oriented, Republican type thing. I know I'm basically a biased individual on the show because I'm about injured workers and the claimants, and I've been invited judges and so forth and doctors on my show already, and it all comes back to the fact of, we can't be on there because of the insurance industry will look at us as like and blacklist us. I mean, it's the bottom line. It's about the money and control. And here again, about money, they're wanting to put more money in the insurance company pockets and take away from the injured worker. To me, it's so ridiculous because the real fraud that's being perpetrated out there isn't by the injured worker. Less than 2% of the injured workers are found fraudulent. And I've said this many, many times. It's probably even less than that with their cases. It's the caregivers themselves, the insurance companies that perpetrate all the different have fraud, the employers that perpetrate a lot of different fraud. I mean, and then the heck of it is the amount of monies that's being paid in to the insurance industry for the premiums for the workers' comp, only a third of that gets back and helps the injured worker. A third, medical and wage laws. The rest of it is eaten up. And you can't tell me that you got to do something like this and hurt the injured worker further. I mean, I was saying earlier, about the attorneys about how basically, and I've said this many times, how the harm that's caused is irreparable if people commit suicide because they can't comprehend and adjust to what's going on in their lives. I just hope people out there are aware of what's going on. You need to stand up for your rights, fight for it. You need a good attorney that you're going to feel confident with. Like I say, hopefully you will get one. I want to make it clear tonight, this show is aired live tonight. It's a live call-in show. If you have any questions concerning workers' comp or something you might have dealt with, please give us a call. The number is 610-378-0426. I'll give it back to you.
Actually, you were talking about the cost and the monies. That's actually an interesting part with
Right.
this bill. The bill is actually alleging one of the reasons they want to do it is to save money. They're not already bringing up the fact that the employers are already having less rates over the last couple of years. They've already accomplished what they were doing with bringing that down.
Mm-hmm.
They mention also about the cost of the medical and how the costs are going up, but the costs are going up for medical treatment all the way across the board. This has nothing to do with just injured workers. They're trying to single this out and trying to say that the cost of medical treatment is just a workers' comp type phenomenon because all the fraud that you're indicating
Right.
that the workers are doing. But that's just not true. That's just not what's going on. The other interesting thing with the cost, this is allowing, which is actually kind of scary if you think about it, this is allowing, and it's specifically stated in the Act, the rules on how they could do it, that the insurance companies can directly negotiate with these providers. So not only do they pick one provider to be on, I don't even want to call it a panel, but to be on the list, so forcing you to go to one place, they also have the ability to negotiate. And unless it goes below 10% of the, I guess, the average or the normal cost, the Bureau won't even look at it. So there's something specifically in the Act that says if it goes below 10%, and hopefully I'm paraphrasing this correctly, Glenn, you can certainly come in if you'd like, but basically if you go below 10%, then somebody in the workers' comp, it's the labor and industry, will actually look at it and try to see if that's okay. It doesn't say you can't do it. It's just saying that they'll actually look at it. Once you start getting into an arrangement where they're negotiating directly with the provider, you come to the point where they could be possibly relying on this money. It could be a big insurance company. We know where their basically loyalties are going to lie, and it's not going to be with the injured worker who comes in and has a problem. And Denny, as you indicated, the injured worker already has enough problems with now trying to figure out if the doctor, who they certainly can't have a rapport necessarily with, has their best interest at heart, or if they're really worrying about the insurance company.
Yeah, there really has to be some appearance of objectivity when you're talking about the treating physician. This isn't an independent medical examination. They have me saying that. It's really a defense medical examination that the insurance carrier sends you for. But when you're talking about a treating physician, the injured worker has to at least have some level of objectivity or some level of trust in. And when you're told where you can go and that the insurance carrier, as Dina indicated, can be negotiating a specific rate with this carrier, with this CCO, it's just a system that is so tied together and so full of conflict and just so anti-worker. And you had said in the beginning about this act when it was created, 15. Yeah. The Supreme Court, when they decide cases, they like to talk about the remedial nature of the act. They like to talk about the humanitarian objectives. and I continually see cases come down and see legislation that gets proposed, and I want to know what's the humanitarian purpose in this?
Exactly.
What's the remedial nature in saying, you got hurt at work, it wasn't your fault, but you're going to go over here where I can get a good deal, and he may not be the best doctor, but who cares?
Who cares about you? Exactly. I mean, that's, another thing that bothers me is the fact that I've talked to employers on different issues before, and it isn't like the employers don't want to, a lot of them don't want to take care of their employees. They want to take care of their employees, but the bull that they're getting from the insurance companies that represent them and the lies that are perpetrated, it really bothers the heck out of me that they're manipulating the system so bad, all in the name of that almighty dollar. I just think, if that's the case, the employers need to stand up, too, for their employees. I mean, you just can't be saying about that almighty dollar. Take care of your employees. If you really want to be, have true employees, there used to be a time, especially in Berks County, that employees would bend over. They felt like the employer themselves was like part of their family, and they trusted them to no end. Well, things have changed so bad over the years, and now there's no trust at all. It's just to be used and discarded as soon as something happens.
Yeah, there are times. Sorry to
go ahead.
interrupt there. There are times where we see an employer that is in the corner of the injured worker, but the insurance carrier doesn't want to hear it from them either.
Right.
They're just a number too.
And that brings up the point that workers' compensation is almost like your car insurance. That unless you have a really large employer that can have some more status and business, something to negotiate with the insurance company, you have each employer is almost like having car insurance where somebody gets injured at work, they report it to their insurance company, just like somebody has a car accident, they report it to the insurance company. The insurance company really just goes to the employer when they need something.
Right.
So they go to them if they need facts, if they need testimony, if they need wage statements, but they really don't have any bargaining power or chips in their corner. As Glenn said, there are some employers that do stand by their employees as much as they can, but a lot of them just sort of the same thing we would do when we have a car accident. We just kind of push it aside. And then we're not going to think about it, and we hope that everything's going to go away and we didn't have to do anything. A lot of times we see that the employers do the same thing. So although we'd like the employers, we'd like it to be what it was 30 years ago, where people worked at the same employer for their entire career, it's just not the way it is now. So people come, go, and the employers either don't want to or don't do a whole lot to keep the employee happy and to make sure that they're getting the right medical treatment that they need.
But sometimes even when they try, the insurance company just doesn't want to hear it anyway.
Exactly, and that brings up the other issue. Although the Act is set up that we have rules and regulations for the medical treatment, and even the way it is now trying to get rid of the caps, we still see the employers trying to send the workers immediately to their on-site facilities.
Right.
There might be a panel in place. It might be a proper panel in place. That doesn't stop the employer from saying, we'll drive you over to work health. That's not really the way it's supposed to be.
Right.
The employee is supposed to have the opportunity and the choice on where they want to go to. So the employers, some of them take advantage now, and they know that the employees don't know any different. They aren't going to say no. They're hurt. They go where they're told. They'll drive them to different places. They tell them this is where they have to go. There's many different ways that they can try to get around the Workers' Compensation Act, and they do it.
All right. Well, at this point, we're going to be taking a break. Everybody out there, please give us a call if you have any questions or concerns. It's 610-378-0426. Thank you for tuning in, and we'll be right back.
You're watching Injured Workers of PA on bctv.org. Be informed. Be involved. Be a member. For membership information, go to www.bctv.org/support/membership. For other information on health and related issues, go to bctv.org.
All right, welcome back. I'm Dennis Straub, your host for the night show, Injured Workers of PA. I'd like to say this show is aired live tonight. Please give us a call if you have any questions or concerns. It's August 19th, 2013. Anything on workers' comp? We're discussing House Bill it's that they proposed. I don't know if it'll get out of basically 1636, if it'll get out of committee or not. Probably, because the House and the Senate is controlled by the Republicans. But we'll see what happens down the road. Hopefully there's enough Democrats that have enough guts to stand up to it out there, and the people need to stand up and call our legislators and let them know.
That's really the key, Jenny, that we have the legislators hear from the insurance companies,
right,
and that they hear from the people writing the big checks, but they don't hear from their constituents, and that's what they need to do. That's where we need the power of the people to be talking to their representatives, to let them know what they want and what they don't want.
Yeah, so please, if you're out there viewing this, or if you view it in the future and you see this, please call your legislators. Let them know this House Bill 1636 is just another bunch of crap that doesn't belong even proposed, that's going to cause more harm than good. They can end up having more people end up committing suicide and inadvertently killing their families too, you know what I mean, in the process. Because in the heck of it is, injured workers, it just says it states, you're a worker, hard worker, your whole life, then you get injured. No reason, no cause of your own. and then you're all of a sudden labeled and restricted from having a life because you're an injured worker. I mean, you're treated worse than a criminal. I can't stress this enough. I've been what happens in the system, and you need to stand up. You need to fight on this for your own rights and for other injured workers. Stuff like this House Bill 1636 needs to be shut down. It shouldn't even be proposed. So please call your legislators. I can't stress it enough. Go ahead.
And whether we're talking about this new CCO, hopefully we'll never be, but or the panel as it exists, one of the trends that we're seeing, and again, this comes down to the dollar, like everything seems to. We've had clients go to a provider on a panel, say it's a properly posted panel, and they go to Dina mentioned Work Health or Coordinated Health or one of these other occupational facilities. The injured worker goes in, and they're expecting to see a doctor, but they don't see a doctor. They see a physician's assistant, or they see a nurse practitioner. I guess that's cheaper. They then come back a second time. They don't see a doctor that time either. I don't know how many times it is that you have to go before you start seeing a doctor, or where it became that you don't have the right to say, well, Dr. X is a part of this facility. Why am I not able to see him? This place is on the panel, so I want to make an appointment with him. Well, the facility may or may not let you make an appointment. Again, you go in and they put you with who they want to put you with.
Yeah, it's the system, the way it's set up, is all about money and who they give you to. Literally, I've tried to guide people in the past on if you get injured, make sure that if they don't follow the proper procedure, especially having you sign that you understand there's a panel of physicians. You can go to whoever you want to. Go to an emergency right away if you have to, but document and get it properly documented on what your injury is. Let the medical professionals document it. I've had this happen where people say, well, I think I did this to my arm. Well, they fell and they might have ruptured disc in their back. They don't even realize it. And if the doctor turned around, you get a proper examination in a medical facility properly, they could say, well, because you also have the back injury or something else. And if you don't get it documented right off the bat at a proper procedure, down the road it's going to cause you problems. So that comes into play. And if you get something like this House Bill 1636 where you have to go to their facilities and you don't get it documented, it makes it all the harder on you and your attorneys to litigate down the road and for you to get back into the workforce and hopefully get back. What really happens is you end up getting blacklisted, labeled because of the injury, and you have to end up suffering down the road where the rest of your life you can't even get employment from other employers. I can't stress enough what injured workers end up going through, especially with catastrophic type injuries. I've stressed this before too. Like most of the injuries that people get on the job, I'd say 95% aren't catastrophic and they're not life going on. And the insurance industry tends to overlook them and have no problem with them when they don't cause problems. But when you get in that 5% bracket where you tear something up or that a back or something that could be lifelong, catastrophic type injuries, they're going to cause you problem and give you hell and then some. And with this particular act, 1630, you're in big trouble. So please make note of that. Go ahead, Glenn.
Well, actually, one thing that you were just talking about with the panel, go to another panel. Very, very often when people come to us and we're meeting with them and they're telling us, I'm within the panel time, I can't stand the doctor, I haven't seen a doctor, I'm seeing a nurse practitioner, they won't send me for a diagnostic study, I'm hurting so much, they keep telling me to go back to work. One thing that they never realize, because nobody ever tells them, is they can go to somebody else on the panel. Yeah. And that's even getting past the part whether or not the panel was done properly with the signing. The signing appears to rarely be done. When we actually want to get them off the panel, we do want to make waves. We've looked at the case. They hate the doctor. They want to get off the panel. We look into it. More than likely, they haven't followed the rules that they need to keep them on the panel. Yeah,
another thing in this bill that I noticed, and basically I always suggested to people that they should go, even if they have any, and the company told them and had to write list 6 doctors in the 90 days, if you need to document right off the bat on what the proper diagnosis of your injury is, to go to your own doctor, even if you have to pay it out of your pocket.
And that's a great point.
Under this bill, the way I read it, doesn't it say in here you're screwed? They're going to cut you off totally?
I don't think so. I mean, we have a lot of questions after looking at this, how this will affect this or that. But what you're raising is an excellent point. People don't understand, even if there is a properly posted panel, exactly what that means. It means that the employer only has to pay for treatment with physicians or facilities that are on that panel. It doesn't mean that the injured worker, as you said, can't go to his own doctor to get his injury documented, to get restrictions if the panel physician isn't giving restrictions that really reflect what the injured worker can do. But I don't know that I read this act to say that part's going to be different. I think you would probably still be able to go to your own doctor at your own cost, same as it is now.
Yeah, the only way we did is it says under elective surgery, even if their panel says you needed it, you can get an opinion from permitted to receive an additional opinion by any health care provider of the employee's own choice. But then it goes on and says that the operation would be performed by their people, not your employee's choice.
Yeah, interesting.
And I'm thinking, what the heck is this?
Interestingly enough, the worst part is that's actually the law now.
What you're talking about has not been proposed to be changed. So actually, the part that you're upset at is the law as we speak.
We were just joking about that earlier, actually.
They shouldn't be allowed to have that control over a person's body and as it is. But I seen it and I think, come on, I didn't realize it was.
Well, the difference is the 90 days.
Yeah.
Because the way it is written now, after 90 days, then you go to your own doctor and you're fine.
Right.
So you're able to go to your doctor, you pick your doctor. So nobody would get surgery during that first 90 days. So if you go through this process and they want to do surgery, you don't want to do surgery with that doctor, you wait 90 days, you go to your own doctor. This is where the change is.
Yeah.
Now they're saying it's the duration.
Right.
So we had a big debate coming here, actually, as to what this means, as to whether or not they can force you to get surgery by some doctor that would not deem qualified. So we send you to a specialist, or not we send you, but you're sent to a specialist. Their specialist says that you need surgery. The claimant doesn't want to get surgery from that doctor. They go to their own doctor. That doctor says, you need this other surgery. The way this is written, you have to go back to surgeon number one and get the surgery done they didn't even want to do.
Right. We have a home viewer, so we'll go to the home viewer. Yes, home viewer.
Yes, I was just wondering, I'm a treasurer of a struggling manufacturer in Pennsylvania, wondering why it makes sense that an injured worker can continue to receive workers' comp well beyond retirement age and even be collecting pension.
Go ahead. Let's take those in two different parts. When you talk about retirement age, especially in today's society, retirement age is something that differs with each person. As society lives longer and longer, people work longer and longer. And really, when you say retirement age, that's not a time that everybody decides not to work. That's really an individual decision. And I don't know that it's fair to say that just because somebody turns 65, somebody turns 67 or 68, or pick an arbitrary number, because that person had a work injury that disabled them, that then they shouldn't get the choice for when to decide not to work anymore, that they should have retirement forced upon them as part of a work injury. I don't think was ever the design of the system.
Well, just picking up on that as well, now over the changes since we started practicing back in 92 for you, 93 for me, the workers' comp has done many, many things to limit the amount of time that you can be on workers' comp. So unless you've got a very, very catastrophic injury, you're going to be limited to basically your 104 weeks plus 500 weeks for your claim, which means you were pretty close to what you're deeming retirement age at the time you were hurt. So just because you get disabled or hurt when you're 64 doesn't mean you're going to be all better when you're 65, when old-fashioned wise that might have been deemed a retirement age.
Right. There's a cutoff period now that was passed under the Ridge back in, the act. Like I say, that it's surprising that they couldn't collect over 10 years to begin with. It used to be before 1995 when they passed that you could basically collect for life. Right. But the bottom line to that is the amount of actions that the employer's insurance industry puts on the individual as far as utilization reviews, so forth, the job creation type thing that they're supposed to interview, IMEs, and so forth, that they put the person through so much stress, the possibility that them wanting to go on collecting on that beyond, especially beyond retirement age, is unlikely. I just, like I say, the person, if they're only collecting 2/3 of what their wage would have been to begin with, and then and then under the employer's view, I think the employers, from what my estimation, I'm going to go to the attorneys on this, but are only subject to payments for that individual for a period, it's only, 2 or 3 years, and then it drops back as far as the amount the employer is responsible as far as the paying in for that employee, as far as their rate. You happen to know offhand? I know in other words, an employer pays for an employee for under workers' comp, and they have to designate.
You're talking about the premiums?
Premiums.
Okay.
Now, employers, the amount they're charged drops back after a period of time, and I think it's 2 or 3 years.
You should consider the premiums the same way, again, going back to the car insurance analogy.
Right.
So they're going to have their own different calculations on how they're going to raise your rates. It is true. You're an employer, your person has injuries, you have lots of different injuries, the insurance company's probably going to raise your rates. That's why they have the straight workers' insurance fund for some employers who have kind of capped out and they need to go to the state-run workers' comp insurance. Right. But the other thing interesting, I think, Glenn, you were writing some notes here, they don't just get to collect after what you're considering retirement age. There's more or less penalties if you're taking your pension and if you're getting Social Security retirement. So,
right. When the Act changed back in
95.
96, yeah,
96,
the mid-90s. Really. There were 2 offsets that were created. One was for Social Security retirement, which the workers' compensation insurance carrier can take half of that amount as an offset against your workers' comp. And then on top of that, if you take a pension, they can also take a credit for the pension to the extent that the employer funded the pension.
Right.
But it goes even beyond that. So they get those 2 things, right? But it goes beyond that. By filing for a pension, the employer can then file a petition for suspension to say to the court, to say to a workers' compensation judge, well, this injured worker's filed for a pension. He's filed for Social Security retirement, so clearly he's removed himself from the labor market. We should be able to cut him off entirely. He's
Correct.
Retired. And courts, unfortunately, and this is a real weakness in the Act also, another weakness that we're talking about, courts are very eager to cut people off in that situation and say you've removed yourself from the labor market, you've retired, and therefore you're not entitled to ongoing total disability benefits.
That's where, and again, I can't stress enough for people to get out there and register to vote and get in office, that politicians, they're friendlier to the workforce than they are to the big business. With the Pennsylvania Supreme Court and Commonwealth Court, but the decisions that are coming back these days are nitpicking at your rights also. Like you were saying, it used to be that the courts would basically side with the employees themselves on that issue. I mean, you should have the right to collect. I mean, you used to be able to collect unemployment and workers' comp at one point, and they took that away from you. That they've managed over the years to keep nicking away at the Act and people's income. I mean, you're only entitled to 2/3 to begin with, and then you're cut off at 10 years. I mean, it's ridiculous. I mean, you didn't get injured on the job because you wanted to be injured on the job to collect. You wanted to keep going, and you were probably happy at your job. And for that to happen to you and turn your life all the way around and put you in the predicament that you're in. I mean, if these employers had to live the way you did or be subjected to what you're being subjected to, they realize that this is no way their employees should be treated or a person should be treated. I just can't stress this enough, and that's one of the reasons. Later on, maybe I'll even tell you right now. I made that poem. I read it before, and maybe you can associate with this. It's called "It's Not a Game." It's not a game when they deny your claim. It's not a game when you suffer physical, financial, and emotional pain. It's not a game when we can't pay our bills and we are in financial strain. It's not a game when we lay awake wandering in vain. It's not a game when we feel we have nothing to gain. It's not a game when we are made to feel we should not remain. Stop the pain, it's not a game. It's not a game we are physical and mentally probed. It's not a game when all our medical history is exposed. It's not a game when we're subjected to medical examination by doctors of the insurance company choosing. It's not a game when we are harassed, followed, and videotaped. It's not a game when we are denied human dignity, morality, and justice. It's not a game when we feel we have no rights. It's not a game when we feel we have no privacy. It's not a game when we feel we have no life. It's mourn for the dead and fight for the living. It's not a game. I can't stress enough. I mean, I still lay awake in bed at night thinking, why should me or anybody that gets injured in a job be subjected to all this mistreatment in the way you are? And there's no way that anybody should be treated like this, especially because you got injured on the job. I'm sorry.
No, just to kind of deviate from where we are, but on that topic of whether this is a fair act or whether this is a humanitarian act, just turning to not every injury is physical. There's psychological injuries. And I don't know if you've spoken on your show before about psychological injuries, but they have a different standard of proof than physical injuries. You have to have an abnormal working condition. And a couple of cases came down the last couple of years where people were robbed at gunpoint. And they suffered post-traumatic stress disorder, which I would think would be fairly logical, fairly rational. We're not used to that. And the court said that that's a normal working condition because it was in part of their training. We don't know why it was in part of their training, but because it was in their training, it's a normal working condition. So, you know, we're talking about the access to the medical treatment, and we're talking about the ability to cut off the injured worker, not cut them off. But sometimes it even goes beyond that with whether they even get comp to begin with. So there's so many ways that you can look at this act and see how it went somewhere so wrong.
Oh, yeah.
It in its initial thing, like you had said, it was designed to help people. It was designed to help the injured worker, and somewhere it just veered off sort of over to the right a little bit.
Yeah, I can't stress enough, again, what takes place here. I mean, people, the viewing audience, I know there's a little bit of a following out there that can feel, because they know my passion and the feel of what's go on and what takes place and what you're subjected to. And if there's anybody who wants to call in and let us know how you feel, I mean, and what you were subjected to. I'm sure that I'm not alone in this, because I know I've talked to thousands of people over the years and what goes on. And you need a good attorney right off the bat. You need a good physician, and then they're going to take that away from you if this bill is passed, it's going to be on your side. You need that backing, and you need to take some of the stress off. I mean, literally, it gets overwhelming, the stress that comes to play. Even if the stress wasn't incurred on the job that you had initially when you got injured, they put you through this stress once you're off on the injury. You figure financially, you think there's a setup within the system that's going to help subsidize your wage loss, and it's going to take care of you medically and get you back on the road, and that doesn't happen. Go ahead.
Well, that's actually one thing that also doesn't get noticed too often, and people don't know because the employer certainly isn't going to tell you. When your life is altered and shattered, you go to work for 30 years every day, and all of a sudden one day you can't go to work. So now the doctor says that you're hurt, you need to stay home, you're not used to staying home, you're not used to having 2/3 of your salary, you're not used to paying your bills that way, you're not used to waiting for your checks when the insurance company is going to get around to mailing the checks. It becomes very stressful.
Well, not only that, but I mean, not just 2/3. The cutoff. They have a cutoff on the amount of wage, the stipulation you can collect. They don't consider your benefit package. No. I mean, that's a big one in itself. Yep. I mean, my particulars, I was making back in the, when I got injured, I'd say not a third, maybe 20% of my thing was wage, with benefits above and above my wage. So I was making like 770 plus benefits were, another few $100, but it was, and they don't even consider that.
Well,
I mean, and there's a
nobody-
lot of people out there today that are the same way.
And nobody realizes my biggest pet peeve with the entire workers' comp act hasn't even been mentioned yet is the health insurance that you work going
Oh,
back to
sure,
my
there's the
30-year
benefit.
worker.
Right.
I'm the provider. I'm the 30-year worker. I've had the same company. I've got the same job. I'm the one who has the health insurance. I get hurt at work. Goes through whatever the rules are in that company. Maybe 90 days later, now I don't have health insurance. My whole family doesn't have health insurance.
Exactly.
And there's nothing in the Workers' Compensation Act to protect the health insurance. That's my number one peeve. So if anybody really wanted to call their representatives, that's the one that they should be doing.
Sure.
Because that's outrageous.
Exactly. Yeah, that is outrageous. But, I mean, that's part of the act. I mean, that gentleman that called in a little earlier is concerned for his company, and he's a bookkeeper, and literally, I mean, hopefully he's watching this shit, that the people, what they're losing is tremendous. I mean, there is nobody in their right mind that would want to get injured on the job and keep collecting on. And then there is a cutoff, too, so literally the timeline and so forth today. And then the insurance industry puts all kinds of pressure on you to begin, you know.
Well, that was the other thing I just wanted to bring up, that people don't realize that they can actually go to a doctor. You can go to a psychologist or a psychiatrist if you're having so much stress from this whole life-altering, and it is part of the work injury. So as long as it's reasonable, necessary, and related, they have to pay for it.
Well,
and
they're
nobody
supposed
tells
to,
them
right,
that.
right.
So they need to go and get the help that they need to get. I mean, you talked about suicide. You taled about, obviously, that's very
Right.
extreme. But there's someplace in between people where people are sitting home and they're just depressed or
Right,
they're anxious.
Exactly.
And they need a little bit of help. And
I mean, I've helped individuals over the years, especially the group that got, you know, they were in that state. I said, you need to go tell your doctor that so they can refer you to get that mental help that you need. And then they did. And they ended up going to court for that, too. And the courts at the time were exactly, you know, it's a little stressed, you know, for them to, the judges to alleviate it, and, you know, for mental. But they had enough evidence, the individuals would get that. And it strengthened, anything you can do to strengthen your case. And that strengthened their case. I mean, what they were subjected to, and they had, you know, that backing, you need to document that and do it. Anything you can to strengthen it. That's another thing that I try and, like I say, guide people through and let them know that that avenue is available for them out there.
Yeah, not just for
Right.
strengthening, but as you say, for adjusting
Right.
to life with this new condition. I
Right.
can't pick up my son or my daughter. I
Right.
can't coach them in softball. I can't help my wife clean the house. I can't mow the lawn. These I guess I'm being gender specific with that, but these are things that are difficult to adjust to, and they can easily lead to depression, to anxiety, to things like that. And you're absolutely right that the injured worker needs to take care of himself or herself and needs to get this proper treatment so that they can adjust to this.
Yeah, I mean, even on that end of it, I mean, the simplest things, they expect that you're not supposed to have a life because you got injured on a job. I mean, they set these little games they play with private detectives. They'll pay $1,000 a day for them to watch you, and they'll even go to the fact of setting up things like lay change on the ground. Oh, look, they bent over and picked some change, or if you have to mow your grass. Well, if it's not beyond your restrictions, you just shouldn't have to worry about that. If your doctor says, hey, you can mow your grass, you can bend over, pick change up, but they'll put this on a video and say, hey, look at this guy, he's doing this. You know, I mean, it's not like a work, like you're doing something for 8 hours like you'd be on your job. Yeah. I mean, I've had private detectives on my show and on my meetings already, and, you know, they basically said, hey, we work for you, too, you know. We'll document as far as if they don't have that for 8 hours or if they spliced it or something, it's not supposed to be submissible in the court. And, you know, I mean, but yet they'll put it out in the news. Hey, this person went on vacation. They went down to the Bahamas.
How dare they, right?
Out there they go on a vacation. I'm appalled, you know. And then you get something like this House Bill 1636 that they're proposing now. We only have, like, I guess 3 minutes left or something. So if there's anybody out there that's watching this show that wants to give us a quick call, you can. Either that, like I say, the show's repeated on Wednesday at 5 p.m., Thursday at 8 a.m., Monday at 2 p.m. Regular scheduled shows on Tuesday, September the 2nd, and that's repeated again Wednesday at 10 a.m., Friday at 3 p.m., Sunday at 12 noon, and you can watch it in archive shows. at bctv.org. And my next scheduled show is for November the 4th, 2013, 8 p.m. I think I'm going to have one of the guests will probably be from Pond Lehocky at that particular show, one of the bigger firms. In fact, I guess that's probably one of the biggest workers' comp firms in the state of Pennsylvania at this point. And our next meeting for the Injured Workers of PA is on Tuesday, September the 10th at 7 p.m. And it's located at Teamsters Local 429 building. That's 1055 Spring Street in Wyomissing, PA, up from the 3A's building in back of Palmer Candy. If you have any questions or concerns, you can give me a call at 610-376-7942. Like I say, we probably only got a minute left. Is there anything you'd like to say yet?
Well, basically, I think when you're talking about this bill, I guess it's basically jeopardizing the relationship between the actual injured worker and their doctor. And a lot of the things you're talking about is being able to tell your doctor and discussing what you could do. And that would all go away when the doctors are basically working for the insurance companies.
All right. Glenn, is there anything you'd like to say?
Other than an agreement with that, one of the things that our firm does, off topic, but on topic of injured workers and their rights, we have a blog on the internet. We try to keep the general public, injured workers and others informed of cases that come out, developments with the Bureau, and things like that. So the link is on our website, bnlegal.com. And information is important. It's important for the injured workers to know it.
Very important, the information that you get, and hopefully we can give you more down the road. Well, thank you for being my guest tonight, Glenn, and thank you, Dina, for Brilliant, the law firm of Brilliant and Nyman. And like I say, thank you, the viewing audience, for tuning in tonight, and for the gentleman that called in. Hopefully we answered your question. And if you have any questions, give me a call, and we'll get back to you. And I'd like to say thank you again, and goodbye, good night.